Welcome to Test 7 review. Let's first examine the tests that we've talked about throughout this unit. First is the Lemon test. This deals with the excessive entanglement of government and religion. It is a three-pronged test. And the first prong is, does the state program have a secular as opposed to a religious purpose? Does it have as its principal effect the advancement of religion? And lastly, does the program create an excessive entanglement between church and state? The programs most likely to withstand scrutiny under the Establishment Clause are those that have a secular purpose, have only an incidental effect on the advancement of religion, and do not excessively entangle church and state. I'll give you an example. The court upheld an Ohio program that gave vouchers to parents to offset the cost of parochial schooling. The justices ruled that the purpose of the program was secular, not religious, because it was intended to provide parents with an alternative to the Cleveland Public Schools. Any aid to religious institutions, in this case mostly Catholic schools, was indirect because the primary beneficiaries were the students themselves. Finally, there was little entanglement between the church and state because the parents received the vouchers based on financial need and then were free to use vouchers as they pleased. There was no direct relationship between the religious schools and the state. And remember, the Lemon test goes with the First Amendment. It's also applied to other cases involving the Establishment Clause. All right, so let's look at the obscenity test that was established in Miller versus California. Also a three-pronged test. Something is determined to be legally obscene if the average person applying contemporary standards finds that the work taken as a whole appeals to prurient interests, and that is, tends to excite unwholesome sexual desire. Secondly, the work depicts or describes in a patently offensive way a form of sexual conduct specifically prohibited by an anti-obscenity law. And lastly, the work taken as a whole lacks serious literary, artistic, political, or scientific value. That's known as the lapse test. The court affords the least protection when it comes to obscenity. All right, so then we have the three scrutiny tests. The first one is the strict scrutiny test, and these are the guidelines the court uses to determine the legality of suspect classification-based discrimination. On the basis of this test, discrimination is legal if it is a necessary means by which the government can achieve a compelling public interest. It is very, very difficult for the government to prove a compelling public interest when it comes to suspect classification-based discrimination. Next, we have the heightened scrutiny test. These are the guidelines used most frequently by the courts to determine the legality of sex-based discrimination. On the basis of this test, sex-based discrimination is legal if the government can prove that it is substantially related to the achievement of an important interest. It was established in Craig v. Bourne. Difficult to prove. The government has an important interest in this, but sometimes they can. And lastly is the ordinary scrutiny test. On the basis of this test, discrimination is legal if it is a reasonable means by which the government can achieve a legitimate public interest. This most oftentimes relates to age discrimination. So for an example, the fact that you cannot in the state of New York get a driver's license until 16, the fact that you can't drink till you're 21, there's mandatory retirement ages in some professions and in some states, all of those things are usually upheld. All right, so the court cases that you have to know for the test, I'm going to go through just in a list, but I have put the ones that you have identified needing assistance with in the Prezi. So there are some on the list that are not in the Prezi. Here we go. Tinker versus Des Moines, Lemon v. Kurtzman, Engel versus Vitale, Neer versus Minnesota, Lawrence v. Texas, Plessy versus Ferguson, Gitlow versus New York, Miranda versus Arizona, Roe v. Wade, Dred Scott, New York Times versus the United States, Schenck versus U.S., Bradenburg versus Ohio, Gratz versus Bollinger, Grutter versus Bollinger, Texas v. Johnson, Gideon v. Wainwright, U.S. v. Nixon, Barron v. Baltimore, Mapp v. Ohio, Regents of University of California, Davis Medical School at Bakke, and Brown versus the Board of Education. So let's go through the ones that you have indicated you need assistance with. Neer versus Minnesota establishes prior restraint. This means that, for example, the government cannot prevent a newspaper from publishing a story. So this establishes the concept of prior restraint, and then prior restraint is at issue in New York Times versus U.S., dealing with the Pentagon Papers. Schenck versus the United States establishes the clear and present danger test and determines that your rights are not absolute, including your freedom of speech. Remember, that's a First Amendment case. Engel versus Vitale, SCOTUS rules that state-sponsored prayer violates the Establishment Clause of the First Amendment. Brown v. Ward, through the 14th Amendment guarantee of equal protection, SCOTUS ruled that separate but equal, from Plessy, is inherently unequal. And then remember, it's Brown 2. This isn't on the test, but Brown 2 is the one that establishes the with all deliberate speed clause. All right, continuing on, Gitlow versus New York, also a First Amendment case that incorporates the right to freedom of speech. This begins the process of selective incorporation because remember the court in Barron v. Baltimore said that total incorporation was not going to happen because at that time the SCOTUS felt like the intent of the Bill of Rights was to deal with your relationship between the federal government and yourself, not the states. Gregg v. Georgia, SCOTUS ruled that the death penalty is not necessarily cruel and unusual punishment. This is the Eighth Amendment. Remember, Furman versus Georgia said that the death penalty was a violation of the Eighth Amendment, but then the states came back with a new generation of death penalty laws, and so now in Gregg v. Georgia they said that those new generation of laws were constitutional. Dred Scott v. Sanford, that should say SCOTUS, I'm sorry, declared that slaves are property. The 14th Amendment, in theory, overturns this through the Equal Protection Clause, although we know that that's not necessarily the case in practice. Lemon v. Kurtzman establishes the Lemon Test and deals with the Establishment Clause. We just went through that with the Lemon Test. And lastly, the ones that you indicated you needed assistance with. Gideon versus Wainwright incorporates the right to an attorney, and that is a Sixth Amendment case. Okay, so the Bill of Rights are not part of the original Constitution. They also acknowledge the existence of rights not explicitly mentioned. That's where the Ninth Amendment comes in. Most of them concern criminal defendants. The 14th Amendment applies some of the rights in the first 8 amendments to the states. That's known as selective incorporation. And also protects against ex post facto laws. These made prior acts illegal once a law was passed. So in other words, if you do something on Monday and they pass a bill on Friday, they can't go back and charge you with a crime. The First Amendment, the rights of freedom of speech, press, assembly, religion, that's free exercise, or the Establishment Clause, cannot be limited by Congress. That's the important part of that. The right to assemble includes KKK holding a rally as long as it is a peaceable assembly, and that's the actual language from the Constitution, peaceable assembly. And that was actually stated in the McCutcheon case this week by Justice John Roberts, that if we're upholding the ability for the KKK to have a freedom of speech in a peaceable assembly, then we can also uphold the right to campaign donations. The Free Exercise Clause protects voluntary prayer by students before school, but does not allow you to break the law in the name of religion. The Establishment Clause prohibits Congress from establishing a state religion. And symbolic speech, whether it be armbands from Tinker or burning the flag, in Lawrence v. Texas, the court has protected this. Back up. That was Texas v. Johnson, not Lawrence v. Texas. I'm sorry. So make sure that you realize that symbolic speech dealing with the burning of the flag is Texas v. Johnson. All right, so the Fourth Amendment guarantees protection from illegal search and seizure. The exclusionary rule, incorporated by Mapp v. Ohio, prohibits illegally obtained evidence from being used in the courts. The good faith exception is designed to allow the admission of evidence obtained illegally by officers who believed they were acting within the law. And the inevitable discovery clause will allow for illegally obtained evidence if the people can prove that they would have discovered the evidence anyway. Amendments continued. The Second Amendment was not incorporated to the states until 2010. And the Third Amendment has not been incorporated to the states. We discussed that in class. And then the Fifth Amendment, right to a grand jury, has not been incorporated to the states. Also remember in the Fifth Amendment that eminent domain clause means that if the government seizes your property for a government purpose, they must pay you market value for it, which is what was happening over by the Kamikaze Curve construction over in Binghamton, and also when they did the 201 flyover in Vestal in Johnson City. All right, the 15th Amendment enfranchised formerly enslaved people. The white primary grandfather clause, literacy test, and poll tax were a reaction to the 15th Amendments. We discussed that in class when we did our end of the chapter questions. The 19th Amendment grants women suffrage. The 24th Amendment outlawed poll taxes. And remember that you want to practice on Bubba Brain, your vocabulary, your amendments, and your court cases.